Hello everyone, welcome to the YouTube channel of iashub. Myself Matthew, and in today's Pulse of the Present series, I'm going to take two interesting topics for discussion, and that would be the Enforcement Directorate and Prevention of Money Laundering Act of 2002. The reason for selecting these two topics are quite obvious because, as all of you know, there are many recent controversies associated with these two topics. The issue aggravated after the arrest of the Delhi Chief Minister, Mr. Arvind Kejriwal, and now the opposition leaders, okay, and many of the members of the press community, they are characterizing Enforcement Directorate and PMLA Act as a tool for the ruling party government to attack the opposition leaders and to curtail the freedoms offered in a democracy. In that scenario, as a UPSC aspirant, you guys should have a comprehensive knowledge about this regulatory body called ED, as well as the legislation that provide immense power to Enforcement Directorate. This could be asked for your preliminary examination in the polity part. When it comes to mains, this could attract questions from the GS2 paper as well as from ethics paper. So this is very important subject for a UPSC aspirant. So we are going to cover this entire topic in a very comprehensive manner. First, we will start with the Enforcement Directorate. Basically, ED is nothing but a law enforcement as well as an economic intelligence body of the government of India. It had a very humble start. Okay, it was formed in 1956 as an enforcement unit within the Department of Economic Affairs. But later on, it was shifted to the Department of Revenue. And here you should understand that both these departments comes under the Ministry of Finance. So it had a very humble start, but later on, many further legislations were enacted in the Indian Parliament, and it gave statutory recognitions to many of the functions of Enforcement Directorate. Being said that, we are going to look into the laws that actually give statutory recognition to the present functions of Enforcement Directorate. ED is a regulatory body as well as a statutory body because of four laws. First being the Prevention of Money Laundering Act of 2002. And as per this act, ED can involve in cases related to money laundering. And if money laundering is involved, ED has the power to investigate, prosecute, and even attach the properties associated with the proceeds of crime. The second important act which you should remember associated with ED is the FEMA Act of 1999, okay, Foreign Exchange Management Act. As per this act, ED is empowered to check the foreign exchange violations. Okay, and this act empower ED to conduct investigation, adjudication, and even imposition of penalties. And the third act would be the Economic Offences Act 2018. Okay, this act came after the curious cases of Nirav Modi, Vijay Mallya, etc. So ED could target these types of willful defaulters as per the Economic Offences Act 2018. And finally, you should also remember one more act. It is known as the Coffee Posa Act of 1974. It stands for Conservation of Foreign Exchange and Prevention of Smuggling. Okay, Conservation of Foreign Exchange and Prevention of Smuggling Act of 1974. And as per this act, ED can look into foreign exchange violations as well as smuggling. Okay, so ED eventually evolved into a super regulatory body just like NIA in India. And that is the main reason why ED is under immense scrutiny and criticism recently. And when you discuss ED in an examination point of view, it is also imperative to understand the structure of the organization. For our examination, you should at least know about the appointment, okay, the procedure followed for the appointment of the Director of Enforcement Directorate. See here, the procedure is being done not as per the 4 laws which we discussed earlier. Whereas the procedure followed will be as per the Central Vigilance Commissioner Act 2003. As per this act, Director of the Enforcement Directorate should be appointed under the recommendations of a 5-member panel, and that 5-member panel should be headed by Central Vigilance Commissioner. The other members should be the secretaries to the Home, Finance, Personnel and Training Ministries. And there were some controversies regarding the tenure of the Director of Enforcement Directorate, and it was finally settled by the court, and a further amendment which was followed in the parliament. So in the present scenario, the director could enjoy a tenure of maximum 5 years and minimum 2 years. Okay, the law says that the tenure should not be less than 2 years, and government brought amendments to the Delhi to the CBC Act as well as the Delhi Special Police Act, and as per that amendments, the government can extend the tenure to 1 year for maximum of 3 times, which means the tenure of the director would be from 2 to 5 years. He should have a tenure of minimum 2 years and maximum of 5 years. This is the information which you should have when it comes to the appointment of director. Next, when you want to comprehend, if you want to comprehend the present political context, you should have an idea about the jurisdiction of Enforcement Directorate. Okay, we discussed 4 laws that give statutory recognition to the Enforcement Directorate, and you should always remember that all these laws which we discussed, they are applicable across the country, which means ED can take cases against individuals as well as legal entities across the country or within the Union of India. That is the first thing which you should understand when you try to comprehend the jurisdiction of ED. Secondly, unlike NIA, ED cannot take suo motu cases, even though ED handles transnational crimes like money laundering or narcotics trade. ED does not have the power to take cases on a suo motu basis. ED can only initiate proceedings once a complaint is registered with any other enforcement agencies. Okay, then ED can take up the charge, and the cases will be resolved by either the courts established by PMLA Act or other courts. The third thing which you should keep in mind is that ED also has the power of a civil court. Why we can say it? Because ED has the power to enforce the attendance of an accused who was summoned by the ED. That is the reason why Mr. Kejriwal was arrested. He had given 6 summons, but he did not appear. So ED has the power of a civil court to ensure the attendance of the accused, and to ensure the attendance, the organization had to arrest Mr. Arvind Kejriwal. So this is the jurisdictionary power associated with ED. Since we have completed the basic understandings, basic informations regarding Enforcement Directorate, let us move on to the next topic, that would be the Prevention of Money Laundering Act 2002. See, PMLA Act was enacted in 2002 by the Indian Parliament because we were a party to 2 important UN conventions, as well as a member to an important organization named Financial Action Task Force. Okay, the first UN convention was specifically targeting the narcotic trade. Okay, it is known as the UN Convention Against the Illicit Trade in Narcotics and Psychotropic Substances 1988. It is commonly called as the Vienna Convention. By 1988, the narcos and the narcotic trade was actually destroying communities So there came an international effort not only to curb the narcotic trade as well as to prevent the black money created by the narcotic trade being laundered. Okay, so that is the background of the first convention. The second convention, the Palermo Convention, it specifically targeted illicit trade of human beings or human trafficking. Okay, in 1990s, these people also created billion-dollar industries, and they were laundering black into white. This convention was created to prevent that thing. Okay, and the third reason was the recommendations of financial action task force. See, by the beginning of 21st century, world was witnessing new challenges like the rise of extremist and militant organizations, and all these black money created by the organized crime networks were actually ending up at the hands of these militant and terrorist organizations. So the Financial Action Task Force recommended to the member countries to take stringent action. So there was an international obligation on the side of India to create a stringent law to tackle narcotic trade as well as organized crime network. This is very, very important. What is the main reason behind the enactment of PMLA? First thing, to target narcotic trade. Second thing, to control organized crime network. Okay, this is the basic function of PMLA. See, that is the main reason why PMLA offences are considered as criminal and not civil. See, if you compare it with FEMA Act, okay, ED draws powers from both PMLA and FEMA. But for FEMA or Fugitive Economic Offenders Act, these offences will be tried under civil laws, but the offences under PMLA are considered as criminal cases and will be tried in criminal courts. Why? Because stringent action, okay, a harsh regime was required to control the transnational organized crime networks. This was the base of enactment of PMLA Act. Since PMLA Act was enacted to create a stringent regime, it also attracted many criticism over the course of time period. As in an examination point of view, it is very important to look into some of the valid criticism associated or directed against the ED as well as the PMLA Act of 2002. First important or valid criticism, the expansion of PMLA schedule. See, in 2002, there were only 6 offences in the schedule of PMLA Act. But later on, amendments are made to the Act in 2015, 18 and 19, and now at present, the schedule of PMLA Act contains almost 30 offences. It even has offences that could be considered as civil in nature. Okay, like for example, the GST taxation violations could be also investigated by the ED as per PMLA Act, which is normally considered as a civil case violation. That is the one of the major argument put against the PMLA Act as well as the involvement or the usage of PMLA Act by ED. The second thing is, the second valid criticism would be against the blanket power enjoyed by ED due to the PMLA Act. See, the section 50, okay, the section 50 of PMLA Act allows ED to summon a person, arrest or search or investigate or even seize the properties without a warrant by the court of law. Okay, without a warrant by the court of law, PMLA enjoys these types of blanket protection as per the section 50 of PMLA Act. The third important valid criticism is around the ECIR. ECIR is nothing but Enforcement Case Investigation Report. It is actually similar to FIR, but here ED treat it as an internal document. And as a result of that, this ECIR is not available to the accused. Imagine you are being summoned or investigated by ED. Okay, you could be summoned, you could be questioned, but you will not have any idea about the case that was charged on you. And as a result of that, many legal experts consider this clause, okay, this ECIR, the nature of ECIR, as a grave violation of the principles of normal criminal procedure laws, in almost all systems. So these are some of the valid criticisms associated with PMLA Act and the usage of PMLA Act by ED. The fourth point would be the concept of the self-incrimination being violated as per PMLA Act. Okay. See, you might have studied about fundamental right under Article 20. What does it say? It actually gave protection to an individual from being compelled, okay, to testify against himself. No person should be compelled to testify against himself in a court of law. That is actually a fundamental right. But the PMLA Act, it violates that basic fundamental right. As per the PMLA Act, the accused could be called upon to make statements and to produce documents or statements, okay, to make statements or produce documents that are admissible in court of law as evidence. This amounts to self-incrimination. Self-incrimination is actually a violation against the fundamental right given to an Indian citizen as per Article 20 of the Constitution. Now move on to the fifth valid criticism. See, PMLA offences are treated as cognizable and non-bailable. Okay, cognizable means, without warrant, ED can investigate someone or seize properties. So all the PMLA offences, they are cognizable in nature as well as they are non-bailable. See, you could avail bail, but there are many stringent or strict conditions for it. It is oftenly termed as the twin conditions for bail. Okay, in PMLA terminology, it is often termed as the twin conditions. What are those two conditions? Prima facie, the judge should have dissatisfaction with the ECIR. Secondly, judge should have a conviction that the accused will not commit no further offences. This is actually the twin condition is actually quite stringent, and it has made bail quite impossible. Take the examples of Delhi Education Minister, okay, the ex-education minister, Mr. Sishodia. He has been languishing in jail even without conviction. Why? Because PMLA offences are cognizable and non-bailable. You could avail bail, but there are stringent or strict conditions for it. So it actually made quite impossible for bail. Okay. Another important grave issue raised against the PMLA Act is that PMLA Act actually put the burden of proof on the accused. Okay. In a normal legal system, the burden of proof is with the investigator. Okay. An accused is innocent until proven guilty. But the PMLA Act completely hijacked or completely overthrown that concept, and it introduced the reverse burden of proof. Okay. The accused, the burden of proof to prove himself innocent, okay, is put on the accused. Okay. PMLA courts will treat an accused person as guilty until proven innocent. Okay. This actually could be seen in the section 24 of PMLA Act. And the last valid argument placed against PMLA Act is that, and the ED, okay, not PMLA, ED, is that the functioning of the ED actually affect federalism. See, democratic decentralization is very important for the healthy nature of any democracy. So affecting federalism is actually a valid argument. Why the activities of ED is affecting federalism? Because ED does not need the recommendation of state government to initiate their investigation. Okay, but some other central investigation agencies like CBI, they actually need the recommendations of the state government to initiate investigation. But unlike CBI, ED does not need that. Okay, and here the problem is that, see, ED is not the only agency that has this exclusive privilege. NIA also does not need the permission or the recommendation of the state government, but the offences that are the offences that are put under the NIA Act are actually quite exhaustible. Okay, but unlike NIA, the PMLA schedule contains almost 30 offences, and we can consider it as overbroad. Okay, so the activities of ED hence is seriously affecting the federal nature of our democracy. So these are some of the valid criticisms placed over ED and PMLA Act. And when you look into the criticisms of ED and PMLA, I think it is also valid to look into the criticisms on the present ruling party government. Okay, the ruling party government is also under tremendous attack in the name of ED and PMLA, and we are going to look into some of the valid criticism. The first being, see, PMLA was actually supposed to be a comprehensive statute. It was made stringent just to focus on narcotics and organized crime networks. But now, the present ruling party government, they amended, the act through finance bills in 15, 18, and 19, even to include civil crimes. Okay, this is actually a valid criticism on the present ruling party government. The second thing is the political motive behind the investigations. Okay, the opposition members are crying over the fact that ED investigate only against the opposition members, and the political motive of the cases initiated by the ED is actually reflected in the conviction rate. Okay, see, the conviction rate of the cases taken up by ED from 2011 to 2022. Okay, from 2011 to 2022, the conviction rate of the cases initiated by the ED is just 2.5%. Even with this immense power and stringent provision, the conviction rate is just 2.5%. And the critiques of the present ruling party government argues that this is mainly because all these cases does not had a solid base. It was just a political vendetta to suppress the opposition. And finally, another important governance issue should be also highlighted, and that would be the PMLA appellate tribunal is highly understaffed. Okay, as per the data in 2022, out of 5 committee members, only 1 member were serving. So what is the issue behind this? Imagine you are being denied justice. There will be a delay if you seek justice. Okay, so justice delayed is actually justice denied. So this is the issue regarding the third point. So these are some of the issues associated with the governmental measures. But the serious criticisms and accusations against the government regarding the PMLA Act would be discussed in this slide. See, many people, they were unhappy with the stringent provisions of the PMLA Act, and they took up the matters to the apex court. And there came a judgment by the court in a case named Nikesh Tarachand Shah versus Union of India case. Okay, and in that case, the court struck down the twin condition for bail as unconstitutional. Okay, and if a court struck a provision of the legislation as unconstitutional, then what is the status? In order to understand that, you will have to go through the Mahendralal Jaini versus the state of Uttar Pradesh. Okay, if the provisions once declared as unconstitutional by the court are treated as if they never existed in the statutes. That is the present constitutional condition of India. So the government, what they did was, they actually tried to overcome this judicial judgment. If a government want to overcome that judicial judgment, at present there is only one condition, which is that they would have to reenact that with appropriate language, so that the court will not struck that provisions as unconstitutional. But the present ruling party government, they did not bother to do that, but they what actually they did was, they took a shortcut. What happened was, in 2018 and 19, okay, in 2018 and 19, amendments were brought to PMLA Act, not as constitutional amendment bills but as finance bill. The main reason for that was, during this point of time in Rajya Sabha, the ruling party government did not enjoy majority, but they wanted to pass this amendments, so they brought these changes as amendments to PMLA Act under finance bills. And these finance bills actually reinstated the twin conditions for bail, as well as put the reverse burden of proof on the accused. So the constitutionality of this method is actually under scrutiny, is actually under immense criticism. Okay, so what do you mean by constitutionality? The procedure established by law should be followed. That is, what do you mean by the constitutionality? So since these things are being discussed in the modern day context, questions could be expected from it. What do you mean by constitutionalism, constitutionality? What is constitutional morality? In prelims, mains, even in ethics paper, these type of things could be asked for your examination. And many people challenge the procedure of the government in the court. But in 2002, still the Supreme Government upheld the expansionary power of ED given by the government as per these amendments. Okay, what happened was, judiciary actually wanted to give the benefit of intent to the legislature. The government argued that these transnational organized crimes, okay, they are very difficult to tackle. They need stringent regulations. Further, India also has international obligations to tackle all these issues. So this stringent law is actually, a stringent regime is actually a necessity. That was the argument put forward by the government in front of the judiciary, and judiciary considers the intent, okay, as genuine, and gave the benefit of intent to the legislature. So at present, the reverse burden of proof, the twin condition of bail, actually exists as a result of that. But this verdict was given by a 3-member bench of the Supreme Court, and this 3-member bench actually left the constitutionality of bringing these amendments under finance bill to a larger bench. And as a result of that, Supreme Court wanted to create a 7-member bench to consider this constitutionality and the constitutionalism associated with PMLA Act. But the present condition is that government sought time to consider their case, and Supreme Court actually heeded to that plea, and in June or July, Supreme Court will take this case under consideration. Okay, the entire constitutionality as well as due process associated with PMLA Act, all will be supervised by, that will be checked by the apex court in June or July 2024. That is the present constitutional position of PMLA Act. And since we discussed many of these things, as a UPSC aspirant, you should have to understand the larger issues involved here. Okay, don't look for the petty politics in these events. As a UPSC aspirant, you should be dwelling into the larger issues associated with this all these current developments. See, what are the larger issues? First of all, constitutionalism. All these political developments, they are seriously affecting constitutionalism and constitutional morality in the country. What do you mean by constitutionalism? Concept that wanted to adhere the principle of limited government. When you look into the present political developments in the or the actions of the regulatory body called ED, we can see that the present ruling party government is actually enjoying immense power. So anyone could argue that this is actually affecting the principle of constitutionalism or affecting the doctrine of limited government. The power of the government should be limited is a very important concept in any democracy. Okay, then you consider the case of constitutional morality. ED targeting only against the opposition members. Okay, the ruling party also rules many of the states, but ED has not even touched any of the miscreants in that states. So these are all bringing the issue of constitutional morality into the forefront. Okay, so these types of things I actually expect in your ethics paper. Second thing is the constitutionality, the due process, as well as, okay, here the due process is under question. Okay, here the procedure established by law is under question. In order to make amendments to a serious law like PMLA, was it prudent? Okay, was it acceptable to take the route of finance bill? So the question of constitutionality is actually a larger issue. The third thing, the stand taken by the three-member bench of Supreme Court, giving the benefit of intent to the legislature rather than the due process. Again, that is also a larger issue. One of the most interesting point which I actually read was that, see, when you go for constitutional analysis, constitutional intent should not be an end. Constitutional intent is actually a beginning of the constitutional analysis. It should not be the end of a constitutional analysis. The end of the constitutional analysis should be around due process. So these are the larger issues here. Again, take the fourth issue. All these controversies are actually bringing ED into a negative limelight. It is putting the credibility and integrity of ED into question. This is actually a grave issue. See, democracy is not a number game. This is a very important thing. Democracy is not a number game. The strength of the democracy lie in its principles and institutions. ED is an important institution of Indian Constitution. So if government is using these type of institutions for political vendetta, it will destroy the credibility and integrity of ED. Okay, that is actually a serious issue. Okay, if the people lose respect towards enforcement agencies, that is actually a grave issue. And fifth thing, now ED is actually handling corruption cases as well. Okay, PMLA Act was supposed to target what organized crime and narcotic business, but ED is actually now involving in corruption cases as well. Then what is the role of CVC? Okay, it is actually if there is a conflict of interest, there is a conflict of functions, okay, with CVC. So that is actually a larger issue. And finally, from the initiation of procedure, okay, if ED initiate their procedure, from there onwards, the individual rights of the accused is curtailed. Isn't that a larger issue? So these are the larger issues which you should keep in mind when you study and comprehend this larger issue. But being an aspiring bureaucrat, okay, being an aspiring civil servant, you should also have some sort of solutions in your mind, okay, because solutions fetch you good mark. So I will provide some of the solutions which you can take. The first solution would be, see, the PMLA should not violate, okay, the basic principles of the criminal procedure, the reverse burden of proof, okay, or that is actually, or the self-incrimination angle. It actually completely violates the basic principles of criminal procedure. And secondly, the stringent conditions for bail. Okay, that could be allowed considering the transnational nature of the crime, but there should be a limit for it. Take the example of again that education minister of Delhi is been languishing in jail for months. For how long he should be in jail? If that is the case of a powerful political person, imagine the case of a normal being. Okay, so the condition, stringent condition or non-bailable nature of the offense, there should be a time limit for it. Okay, if it is related to corruption, see, basically it is the PMLA Act that is actually providing stringent conditions for bail, and PMLA Act directly involves with money laundering. If PMLA Act could, deny a bail, then the investigation agency, the ED, they should be able to prove the money trail. Okay, for example, you can suggest some 6 months or 9 months, and within that 9 months, ED should be able to, be established the money trail. Otherwise, the accused should be given the right to grant bail. Okay, so this could be the second suggestion. And third thing is, see, the resources of the ED should be increased. Okay, that is also very important. Why we can say that? Look at the stats. This status is from the 2022 data. ED actually took up almost 4,700 cases. Okay, but arrests had been made only in 318 cases, and searches were conducted only in 388 cases. This clearly shows the resource crunch of ED. So the resources of the ED should be enhanced, because almost all of the accused will be charged under PMLA Act. Due to resource crunch, the conviction rate will be also low. The integrity and credibility of the ED will be questioned under the eyes of a common man. That is a grave issue. And finally, not giving suo motu power to ED does not make any sense. Okay, just like NIA, ED is also targeting organized crime and narcotic business, which are transnational and highly sophisticated in nature. And giving, not giving suo motu power to ED does not make sense, since narcotics is actually a grave threat to our country and society, and it is transnational and highly sophisticated organized crime. So these are some of the solutions which you can put when it comes to main examination point of view. I think I have completed almost all important aspect of these two cases. I hope this would be very beneficial to you guys. And please, comment your, feedbacks. Okay, please place your feedbacks as comments, and in comment section you can also, request about the, the nature of content, the type of topics that should be selected for the next video as well. So with this, I think I can conclude. A big thank you all.